afternoon, everyone. I'm Angie Davis, and I'm with you here for part 3 of this 3-part series we've been doing that we call Back to Basics. And I wish I was sitting in a room with you so I could ask how many of you have joined us for part 1 and part 2. I hope many of you have, and that you're joining back in on part 3. All of them stand independently, so there's no problem if you haven't seen either of the earlier presentations. But the concept on this Back to Basics series is just what it sounds like, going back to the fundamentals of HR process, because really that's where you live, die, win, and lose, is how you do things fundamentally correct on these core issues. And so we started the series with investigations and looking at those types of issues, and then we have moved into disciplinary issues, the do's, don'ts, and what if you don't, including negligent retention last week. And then today we're going to talk about grievance and appeal process. And for any of you that have been with us, you know, on the first seminar I mentioned to you that we had this massive flood in my office, and I was sitting in a little storage closet when I came to you to present the webinar, and I was still there for presentation number 2. Well, today I'm back in my actual office, so that is progress. But today I had a flat tire. I blew my tire out on Interstate 400. And so I think I'm glad that this is 3 of 3 today, because I've had a flood and a flat tire. And Dan, I'm not blaming it on you, but it's good that I don't have to worry about what comes in week 4, because I think I've had enough in the last 3 weeks of catastrophes. But with all that said, let's go ahead and jump into our grievance and appeal process talk for today. Here's what we're going to work through in this next few minutes that we have to spend. We're going to start with the grievance process, and then I'm going to talk about that distinguished from a formal appeal, and I'll explain how I view those differently. And then we'll touch upon civil service. I know civil service is something that, you know, I would be interested, and maybe you can put it in the chat and Dan can let me know, you know, how many of you have civil service. I venture to say when I talk to clients, I would say probably it's about half and half of people that have a civil service system or do not. But even those that do not have civil service, the grievance and appeal process that most people have in their organizations tend to mirror civil service in many, many ways. And so we'll just touch on civil service. I want to make sure that you hear a little bit about that, but really all of this should be relevant to everyone, irrespective of what type of system you work under when dealing with working through employee complaints. So let's just jump right in. Let me say this to start with, is that a grievance process can be almost anything you want it to be. You know, the key here is to having a written process and then to follow that written process. And that's easier said than done sometimes, particularly if you've got supervisors managing that, you know, at a lower level that doesn't always work through HR. But have a rule, follow the rule. That's your most important thing. And then what that rule is going to vary greatly. So I'm going to try to talk about these issues globally, because I'm very mindful that different communities have different goals, different politics, and then even different systems. You know, many organizations, cities, or counties view their foundational systems very differently, whether you have a city manager, or county manager, or city administrator, or county administrator, or whatever your charter may say about who does the disciplinary process. How involved is your governing authority? You know, is the city council involved in this process, or is the board of commissioners involved? It varies greatly. And so there's not a one size fits all, but what I'm going to try to do is to talk to you about best practices and talk about things that I think is important that you do in your process, but mindful that everyone may have a little bit different system. But I'll be happy to answer any specific questions, as Dan mentioned, as we get towards the end of the program. So in the beginning, I think you need to think of the grievance process. I'm sure you think of it as kind of just a pain in your butt, because for lack of a better, more official legal term, it kind of is. It may be something that, you know, when you get a grievance, you think, oh, you know, it's taking you off your day-to-day routine. It's always time consuming. It's typically always sort of emotional. It's often very adversarial. And I think it always puts everybody on pins and needles, because once a grievance process starts, you always have to wonder and worry, where is it going to end? And is it going to end in litigation? Is it going to result in a claim against the county? But I do think it's really important that when you start a process that you do look forward to that end, because it is important that you conduct yourself throughout with that wonder and that worry about what comes at the end of the line, to make sure that you handle it appropriately so that if you do get sued or have some kind of claim against the county, then you have a really clean, well-documented process to show a court at the end of the road if it comes to that. But the purpose is not to be a pain in your butt. The purpose is to provide this informal process to resolve complaints. And the goal is that indeed you will avoid litigation. So employees are going to be upset about things. You know, they're going to be unhappy with things in the workplace, no matter how wonderful your workplace is. Everyone is going to sometimes probably have something, whether they bring it forward or don't, that they're not happy about. So the notion of having a grievance process is it allows someone to bring forward these complaints under certain terms and under certain conditions. And the goal would be that, hey, if you're heard, if you can see that we are listening to you, you have an opportunity to air your grievance, then perhaps that will resolve it in a positive way. So everybody goes along skipping happily. Or even if it doesn't resolve quite like they want it, even just being heard sometimes is a positive thing that will avoid litigation. So those are our big goals when dealing with this kind of a procedure and process. So who is eligible for to supply a grievance and to get into the process? You know, this is dependent on your policy. And so you may allow everyone to file a grievance. I question here in my first bullet point as to whether full-time employees should be all that's included. And I think I see that in most policies. I think that's a fair thing to do. There's some communities that feel very differently, that part-time employees get all the benefits and they get everything a full-time employee gets, and it's just that they work half-time. I have other community clients where the full-time employees have all the benefits, part-times really get nothing. So you have to decide. It needs to be clear who has the right and who doesn't. And then if you don't specify, make sure, you know, if it just says employees, then you may be intending full-time and part-time. But what about if you have seasonal employees or, you know, or even job-specific employees? Make sure that you're specific on who you intend to have these rights, because once you get the complaint, if you're trying to turn that person around and send them on out the door saying you're not eligible to file it, you may cause worse problems if it's not clear, because then they feel like maybe they've been singled out or unfairly denied the process. So be clear who you intend to include. And again, I think including only full-time employees is appropriate, but if you don't want to do that, you want to be broader, then just make sure. I'm sure you don't want to include seasonal employees probably, or any other type of limited aspect employees other than maybe part-time is the other big category that you might include. Typically, I see that probationary employees are excluded, and I think that's recommended. Typically, you have probationary employees in for a 3 or 6 or 12-month process, and the notion there is that they need to perform up to standards in order to become out of probation and be a regular status employee. Regular status should give with them additional benefits, and I think this grievance process is a part of the additional benefits that probationary employees are entitled to once they have satisfied those probation requirements. Again, it's totally up to you, but more times than not, I see probationary employees excluded, and I think that would be my recommendation so that you have a manageable process. Once you decide who has the right to proceed, you have to decide what subject matters you will agree to hear. And my advice to you is that your policy should say what you intend to hear in your grievance process. You need to be specific. You need to be protective. And by that, I mean, you know, think about putting some realistic confines on your list of grievable matters. And I'll give you an example. And I had a debate on this, and I won't say the name of the county. I don't know if they're on or not, but we had a work session and we were talking about a grievance process. And they had in their policy that we were amending and looking at for updates, they had allowance for grievances on compensation issues. And I suggested that they should consider deleting that because I felt that really got into budgetary matters. That was the Board of Commissioners' purview. It really wasn't an appropriate employee complaint. And some of the commissioners felt very different about that. It was very interesting. But when I say protective, just think through your process to decide, do I really want to hear those complaints? And then the last point is, what are your limitations? Because, you know, do you want to hear them, and what can you really do about them? So if every one of your employees files a grievance to say, we think we should be paid more money, You know, that may be something you can hear from your employees, but I don't think it's something that really is appropriate for a grievance, because as that goes up the chain to a supervisor or to a manager, there's really nothing that they can do. That is strictly going to be a governing authority issue, and it's budget driven. And so you're going to hear from employees all the time about salaries. That's something that's a hot topic right now for sure, with the inflation going on, you know, recession in front of us. And, you know, everything costs more. So employees, there's a lot of issues right now with employees and wages and what's fair and how you can pay employees to retain them. But I still think while you may hear those issues and you may carry forward to your board, those are the kind of issues that go right to your governing authority, because they're the only ones that can deal with it. So just consider when you make up your list of what you can grieve, you know, how narrow or how broad you want to draw those. And then here I'm going to talk to you about a few matters that I see as commonly listed for grievable matters. And again, this can be anything you want, but I think this is a good list to start with. Typically, you can file a grievance for an adverse action. Now, I say as defined, and I'm going to talk about that more in just a minute. But your policy needs to define what those adverse actions are. Again, we'll speak about that more in a moment. Additionally, unfair treatment. And that can, you know, be pretty broad. If someone feels like a supervisor is picking on them for some reason, they get different assignments. Other people get to come in late. They don't get to come in late. I mean, it may not rise to the level of discrimination. It may not be based on a suspect classification, but maybe they just feel like, hey, my supervisor is treating me differently, or something's unfair that's going on. Everybody got new computers. I didn't get a new computer. You know, you may get things like that, but I think unfair treatment is a fine categorical topic for grievances. Next point, unsafe or unhealthy work conditions, kind of speaks for itself. Arbitrary application of policies and procedures. Again, that's a little variation on being treated unfairly. Sometimes I'll see grievances where an employee will say, here's the rule, and my department isn't following the rule. And so that would be an arbitrary application or a failure to apply a policy. I think that's a fair grievable issue. And then finally, alleged unlawful discrimination. So if someone believes that they are being treated unfairly and it's based upon race or gender or national origin or religion or any of those other protected classifications, then that could come through a grievance process. But I'm going to give you the cautionary big stop sign here. Don't let your grievance process eat up your harassment process. And that was our first seminar that we talked about in this three-part series, was these harassment investigation procedures. And so you should have a policy that deals with how you report sexual harassment or how do you report discriminatory harassment. So if you get an employee who mistakenly files a grievance saying, I believe my supervisor has sexually harassed me, then you need to redirect that person to the sexual harassment reporting policy, because that's going to proceed a little differently. There's going to be an investigation, you know, presumably under your policy. That's what I would hope for you in your policy. And it's going to be handled differently than going to the supervisor and then stepping up these chains without having independent investigation tools in place. So I think that's really important. And I think when you give a list of what you can grieve, that I've just showed you on the previous slide, when you mention discrimination, I think you should put a caveat, except that allegations of harassment should be reported per a harassment investigation policy, section 215, whatever. So make sure that one doesn't eat up the other. You want to keep those actual procedures separately. Okay, so what does adverse action mean? It can mean whatever you say, however you define it, but here's what I think is the most common and recommended approach. Allow employees to file a grievance if they're demoted. And I say for disciplinary reasons, because there's times you may engage in a demotion because, you know, there's a reduction in force, there's a job elimination, there is an accommodation because of some kind of physical, a light duty need, or some kind of reasonable accommodation. Those types of demotions should not be grievable, in my opinion, because those are required based upon workplace necessity. Now, if they're discriminatory, that could, of course, be another thing. And fall under the policy differently. But I think otherwise you want to be clear that demotions for disciplinary reasons can be subject to grievance. Secondly, suspensions. Again, I would give a caveat and be clear that it's for disciplinary suspensions. You could have a suspension for an investigation. I don't think that should be grievable because at the end of the investigation, you're going to have a result, and then that issue could be the grievance issue, but not the suspension. You could have a suspension pending a drug test, or a suspension pending criminal adjudication. And in our disciplinary talk last week, we talked about identifying each of those different types of suspensions. That will really help you as you proceed and you're implementing any disciplinary action if you clearly specify these different types of suspensions that are available to you. But I would reserve suspensions for disciplinary purposes as the only type of suspension that gets the opportunity to come through the grievance process. All of the others are sort of a means to an end in a short-term timeout situation as opposed to an end result of a disciplinary suspension. And then, of course, the big daddy, termination. That would certainly fall under an adverse action that could be subject to a grievance process. But what I want you to think about, and we'll talk about more in just a moment, is whether steps will be skipped if it's termination. So typically, I would see grievances, and we're going to talk about this in just a second, but go through varying steps. You know, starting with maybe a baseline supervisor, going up to maybe the city or county manager, and then whatever the final decision is, we'll talk about that in terms of whether that is the manager or whether that could be your governing authority. If someone's terminated, I don't think it's as easily applicable to go through these lower level steps. You can, and some jurisdictions do, but I also think it's appropriate to say if you're terminated, then you skip to the last step. And I think you could consider doing that. But it's, again, however your policy is drafted, there's not a right and wrong. Largely, it's a resource issue in terms of how you can manage these grievances and these appeals. So here are the things that I would suggest to you in your policy that you should be clear are not adverse actions that are subject to a grievance process. I think employees should not have a right to file a grievance for an oral reprimand. You know, that should be a day-to-day way of doing business and correcting employees. And if every time you suggest to an employee to put a comma here and make sure that they, you know, say please and thank you on the phone, if every time you have that kind of an oral counseling type situation, they can go file a grievance, then you'll be doing nothing but grievances all the time. So I think that's important to say. No oral reprimands come through the process. Similarly, written reprimands, those are situations where we haven't taken any money from the employees, and I think that's another bright line kind of way you can think about it. A demotion, a suspension, and a termination that's taken money away, so it's more tangible. Not to say oral and written reprimands aren't important, but I think that's an easy way to justify why you would not send those through the grievance process. And then also any other kind of disciplinary action short of the ones that we said fell under the adverse action definition. For instance, if you have an employee who has a blow up, you know, in the office, and you give them a written reprimand and maybe you send them to anger management counseling. I think that's a great result. It's a great way to go. That training, that should not be subject to a grievance process. So I would specify that though, so it's not unclear. Or if you put an employee on a performance plan where they have to be reevaluated every 3 months, or they have to engage in some kind of a goals and objectives analysis or additional reviews, anything like that. I don't think any of that should fall within a grievance process because that is just how you are managing these employees on a day-to-day basis, and all of that can't be subject to grievance, or again, that'll be your full-time job. Here's some other items that I would say commonly should be excluded from the grievance process. And again, the devil's in the details. You need to say these things in your policy, in my opinion, because when the employee comes in and you look at their grievance and you say, oh, yeah, well, we don't hear that issue. Well, if we don't say that we don't hear it in our policy, then that's going to look like perhaps we're discriminating or singling them out or being uncaring and unresponsive. So the policy needs to say exactly what you intend to exclude. And here are some top items that I think are appropriate and that I see in a lot of policies. First is matters that might be pending in another administrative or judicial proceeding. So if you have an employee who's already filed an EEOC charge of discrimination, then filing a grievance on that same topic of discrimination in the same circumstances would not be appropriate. It should go through the proceeding that it's in. Same thing if there's a court case, then it's not going to go through the grievance process. typically it goes through the grievance process before you get to an EEOC stage or before you get to court, but they shouldn't be going at the same time. Defer to that other administrative proceeding or that other judicial proceeding is sort of trumping your grievance process, instead if they come and ask after the fact. Now, just a little side note, depending on how your procedures are, if they've jumped over your grievance process and gone to the administrative action or gone to the judicial proceeding, then you may have an argument that they didn't exhaust their remedies in the policies. And so that may be a defense for you in those other proceedings, but I would not necessarily conduct the grievance at the same time if that grievance request comes in after the fact, because it's just tenuous to be fighting on different forums and different levels. Work assignments, I don't think those should be included in a grievance policy. Your managers need to be able to assign people duties. They need to be able to switch people's shifts. They need to be able to move them to a different fire station or a different sheriff's office location, a different police station, without every time that someone has something changed having an opportunity for grievance. It just becomes really unworkable, and it doesn't allow your managers to manage if those were grievable items. And I know, as I've heard many times, those can be issues that really cause people to get worked up. They get put on the night shift and they like the day shift, or they get put on a shift to work with people they don't really like to work with. But if there's an issue with it, then it should fall into one of the other grievable items that we talked about. If it's discriminatory, then we need to hear it. But if it's simply that, hey, I don't want to work at night because my child has school and I need to pick her up from school, that's all good and well, but I think that's a work assignment issue. If it's not a discrimination issue, then we shouldn't hear it. It's just to let your managers manage. Budget allocations, expenditures, and organizational structures. We should not hear grievances on those items. I saw one time someone fighting long and hard about, a water dispenser that they wanted. Well, that's something they can certainly pursue, but that's not a grievance type issue unless everybody else in the office got a special water dispenser and this employee didn't, and they allege it's based upon race or gender or some protected classification. If it's not discrimination, then we should not even consider budget type issues, how we spend our money or how we organize your city or county structure as a part of the grievance process. The next item I've heard debated, but it's my recommendation that the content or rating of a performance evaluation not be subject to a grievance. If you do annual appraisals, like I hope that you do, if it was a grievance process, then every employee conceivably in your workplace could file a grievance after every annual evaluation. Now, hopefully everybody's not upset about them, but many people may not be happy with them, and they may not be happy with them largely because they may not get the pay raise that they want, but then they'll blend that into the concept if they didn't like something in the content or the rating. My recommendation is that that should be a separate process. Under your evaluation process, you should have the opportunity for a county or city employee to offer a rebuttal. I think that's important for them to give some kind of statement in response to the evaluation that identifies their position on the issues, and that goes in their file so that everything's heard there. If that rebuttal changes things in the evaluation, then so be it. But I think it has to be, and is best recommended to be confined to the evaluation process. If you take that out of that process and pull it into this grievance process, then again, I think Katie barred the door. You could have hundreds of grievances after every evaluation process, and that would just shut you down. So I recommend that you exclude that. And then finally, the selection or non-selection for appointment, promotion, or transfer. So if someone, applies to transfer to a job and they don't get it, or they apply for a promotion and they don't get it, unless there's a discriminatory allegation about why they did not get the job they want, then just not getting it should not be a part of the grievance process. Again, almost all of these items could become grievable if indeed they have a discrimination component, but if they do not, then they should be reserved as excluded from the process. Here's a few more common matters excluded from the grievance process. If it's outside of the control of the applicable elected official, then I think it should not be considered, because if the relief can't be given, then it does not make sense for it to be a part of a process. Security procedures. Those are procedures that are developed by your governing authority, and they should not be subject to grievance. Decisions, policies, resolutions, or ordinances that are made or passed by your governing authority, those should not be subject to grievance. Now, employees are citizens, so I mean, I don't love it, but I mean, employees can come and speak at public hearings and share why they don't like a particular resolution or ordinance or anything like that, unless your policies provide otherwise, which they probably don't and probably shouldn't. It doesn't mean they can't be heard as citizens on those things, but it's not a part of the workplace grievance process. And then any issue that's complained of by a probationary employee. As I said earlier, I would recommend carving out probationary employees and not allowing them to participate in the grievance process until they've satisfied the probation requirements. So now we've said who's eligible and what can they file about. So now how do we do the process? This is where you get down to the nitty-gritty of the logistics of the grievance process. So you want to make sure that your policy is clear. I hate to say it, but all too many times I'll get sucked into a process and I'll open the manual, the handbook, or the policies, and it kind of says you can file a grievance. It doesn't really say much. And usually I'm getting the question of, well, I think they filed it too late. And I look, and either the timing requirements are super wishy-washy, or maybe there's no timing requirement, or I'll get someone saying, this is so vague, I don't even think we should hear it. And unless our policy has some particular requirements, it's very hard to kick anything back or dismiss something unless there's a clear policy that says here's what's required that they failed. So you don't want to put yourself in a worse situation by having an employee who's already unhappy about something, and then you don't go through the process either following the rules, or you try to deny them the process without having a rule to back that up. And then you're going to take that unhappy person and make them a downright litigious person. And then that's when you see that end of the road pretty quickly in some kind of claim or court. So provide, I think, in your policies that there will be a written requirement signed by the employee. I think that's important. In today's world, people love to kick off an email. But I think it's important that the employee write out their grievance. It doesn't have to be handwritten, of course, that it would be printed on a computer perhaps, but that it's signed so it's clear that it's legitimate, comes from the employee. And then you have something that can never be questioned as to what the employee's complaint was. And that can be important because, remember, I told you I always want you to wonder and worry about what might happen down the road. See the end of the road and say we are in litigation and we have a finding in the grievance process that the grievance was unsubstantiated. And then in that lawsuit, the employee said, well, they didn't even look into this issue. They ignored me completely. And you pull out your document and say, well, no, here's what you complained about, and we addressed it completely. And if it's signed, there's no doubt that that's what the employee submitted. If it's just been kicked over on an email, or if it's just been printed out and handed in without a signature, then you may have to fight that fight. So no need to give yourself just another hurdle. Instead, require it to be in writing, signed by the employee. And then your policy needs to say who should it be filed with and how or when it should be filed. So typically, I think these are filed with a supervisor who then would pass it up to HR. Some policies may have it filed directly with HR. And, the control freak in me kind of likes that, because then that means a manager can't slip up and forget to get it to HR, or a manager who may not remember, oh gosh, in 5 days I'm supposed to answer this, could mess it up. So I think either getting it to a department head, to an elected official, to HR, I think that's a better way to commence this process. But your policy just needs to say who gets that first filing. Now, here's a little more information that I want to share with you on what I would recommend in that written agreement. So I've told you I think it needs to be in writing, and I think it needs to be signed. I would put in your policy that there's the list of things that this grievance has to include. This is for a couple of reasons. One, again, remember that wonder and worry about the end of the road. If you nail them down on what their complaint is, then when they're more aggrieved at the end of the grievance process because they didn't get what they want, they can't go blow it up and embellish once they hit a court. So nail them down on what their complaint is in the beginning. That's when it'll be the most honest and the most credible. And if you don't have a pretty high standard of what will be in that written grievance, then it could be really something that is stated really broadly, and then they get to embellish once they've hired a lawyer and they're trying to make a claim against you. Because it's amazing how sometimes the stories change. Sometimes all of a sudden the stories fit those legal claims because they've got a lawyer guiding them and helping them say those magic words and frame it in just a way that it could be a claim against your government. So my recommendation is nail them down right here, right now, with your written grievance requirement. Put it in the policy. There should be a detailed description of the complaint. What are you complaining about? It can't be treated unfairly. Nope, that's not enough. And if you get something like that, then I think you can hand it back to them and say, I need you to follow the policy in terms of giving me a detailed description so that I can properly address it for you. Doesn't mean you dismiss the complaint, but require them to detail it. I think it's important to have them identify the policy that's violated. This does a couple of things. One, it'll jumpstart you and whoever's looking at it to narrow in on exactly what the complaint really is about. And number two, when an employee has to go look in their manual and find a policy that's been violated, that forces them to be honest with themselves about whether what has happened really is a policy violation or a problem or whether it's not. Because if they have to identify line and verse and citation to a policy and they can't do that, they can't find anything that the conduct violates, maybe that leads them to go away. Maybe it doesn't, but if they can't identify a policy violation, I think that's very helpful for us there down at that end of the road if this grievance ends poorly. I also think you want to make a requirement to attach relevant records. This is just helpful for you in your process. You know, if an employee says, I've been discriminated against because of this and so, and my supervisor sent these mean text messages to me and sent inappropriate emails and posted this picture that's, you know, graphic and sexually harassing, well, those all should be attached. You know, the grievance process doesn't really yield itself well to being a full-blown internal affairs investigation or a full-blown harassment investigation. Instead, the employee should come to you with a package with that detailed description. What was violated? Here are the relevant records so that you can open up that package and then you can address it. Now, you may want to find out more information. That's okay. I'm not saying that you're tied to what the employee shows you, but if you require them to attach relevant records and they fail to do so, then again, that could be used against them in the end. So at the end of the process, way at the end of that road, if they come out with some smoke and gun email and they didn't produce it here when you say attach all relevant records, then at the end of the day, that makes them look a little bit less credible, because where was that smoke and gun record when we told you you were supposed to attach everything that mattered? You know, was it contrived? Was it later created? You know, that I think, again, can help you at the end game, but on the front end of it, it's also just functionally helps and assists you to hear what all is in play and not have to go digging around for it yourself. Also, and I love this one, and I've seen this help so many times, tell them that in the complaint for their grievance, they have to say what relief they want. This one will surprise you sometimes. I actually was on the phone with the sheriff literally 5 minutes before I logged on with Dan here today, and I have him bringing an employee in. We're going to present her with the results from the grievance process. It's not going to end like she wanted it. Her claims we're finding to be unsubstantiated, but she's filed another couple of complaints, and so this is kind of spiraling out of control. So I told the sheriff, I said, you need to say to her, what do you want? What do you want to happen here? Their policy doesn't require that, and so we don't know where she's going. It seems like she's unhappy with everything, but don't know really what she wants, because there's always something the employee wants. So ask them that question. I had this recently occur where we've gone through a grievance process, and it still felt very unsettled. It was a litigious employee. We were kind of just waiting for that lawsuit to come. And again, I said to the department head, you know, why don't you bring her in and see what it is she wants? And, you know, when he did that, she said, I just want to leave. I want to leave. I want a clean record. I would like, you know, to get my vacation paid out, but I just would like out of the organization. And that was music to our ears, because that's exactly what this department director wanted. But had we not asked the question, she was just loading up for battle. But once the question was asked and we knew what she wanted, then we were able to be very targeted, and we ended up with a great resolution, got her out of the organization, And we ended up actually not even completing the grievance process because we didn't have to, because in the midst of the findings and going through where she might have appealed it again, we kind of nipped it in the bud and said, what do you want? And it resolved it for us. Also, and this is just very much a logistic item, but I would have your policy state that the employee has to provide a reliable email address to receive notifications. This grievance process should move quickly. And so we'll talk about timing in just a minute, and it may be that you want to have a 5-day window or 7-day window, but it's going to be quick. And so what we can't have happen is for an employee, and this has happened, say, oh, that went to my home email and I don't check my home email. I didn't get that. So I didn't appeal it, but I don't want to agree with the manager's decision and I want to go to step 2. No, we're going to make you tell us the email address you want us to send the notifications to, and then you better be checking them. And so then if an employee misses that next step appeal, we can say the email was sent timely to the address you provided us, and then they're out of luck. So I think that's a functionally important thing. So I think if you have a grievance process now and you want to just drop in like a provision like this, I think this provision, this slide right here, will save you so much going forward in terms of protecting the process, but then also really setting you up well for that end of the road when everything goes wrong and you may have some kind of litigation on your hands. So your policy should talk about timing. As I mentioned, 5 to 7 days is pretty common, and 5 to 7 days would be from the occurrence of what happened, or if it's not reasonably known when it happened, from the knowledge of that occurrence. So, if something has occurred and an employee says, we had a safety issue in the workplace on July 2nd, and they bring that on August 4th. Well, okay, no, they knew about the issue. It's too late. But if something happened that they didn't know about, and only found out about maybe an unsafe situation that started on July 2nd, but it did not disclose itself to them, like they just happened to stumble upon it, maybe literally or figuratively in August, then if that's when they first reasonably knew of it, then that may be where the clock starts. I'd be careful on that though, because reasonable notice is kind of hard sometimes to nail down. Typically, it's going to be something that the employee knows when it happens. So probably that 5 to 7 day window is going to be spot on most of the time. But there's just sometimes that perhaps, something could have been put in someone's file, or someone could have been moved, or some different thing could have happened that the employee truly does not know. And then it might be reasonable for us to consider taking the clock starting to run from the date of them actually coming to know of that problematic issue that they want to grieve. One thing I think is important as well in your policy is to specify whether you're talking about work days or calendar days. It really matters, because in this short time window, if it's 5 days, then that could be trouble. That can be hard, because let's say something happens on a Wednesday. Well, if it's just calendar days, I'm sorry, I think I was speaking backwards. Calendar days can get tight. If something happens on a Wednesday and your 5 days is going to expire on Sunday, well, then obviously they would probably file it on Monday. But the calendar days means that there's non-work days that not only your employees have to be working on this, but you as well have to be working on this, because whatever timing method you put in place for the employee, it needs to be the same for that manager to respond. Now, I have seen some policies that'll say 5 days for the employee, and then maybe the manager gets 10 days to return the response. I think it's probably better and more fair to make them equivalent. Then it just goes without question. And also, again, you want this to move quickly. You don't want it to drag out over months and months, because this typically creates somewhat of a disruption in the workplace. You want to address it and end it. So my recommendation is to say work days. And if you do that, then 5 work days I think is fine. If it's calendar days, then 7's probably more reasonable, because then you're not going to have something necessarily commanding the weekend. And then again, as I noted at the end, as I just mentioned, the employer response timing needs to be considered as well as to what's reasonable for you in terms of having your manager response to the grievance. So with all of that, sort of the process and how you set it up and how you commence it, Then what happens when you're just in it, in the thick of it? So typically there's multiple steps in a grievance process. And I know I keep saying this, but I'll say it again. It can be whatever you want it to be. So these are options. Your first step could go to a direct supervisor. Very, very often what they're unhappy about is something that's happened either because of the direct supervisor's direct action or because of something the direct supervisor is allowing to happen. And so you may feel like, yep, go straight to the source, see if you can resolve it there. And a lot of employers feel that way. Some though will say, you know what, that's just going to be a waste of time because the direct supervisor is going to always affirm their own processes. And so that's just a wasted effort, wasted step. So we're going to have the first step go straight to the department director or the elected official. It can be either way you want. I don't mind going to the direct supervisor because I think it gives you an opportunity, for one, to be aware of the complaint for a little bit longer before it starts getting up the chain. So if you jump right to your department director and your elected official, then you have truly a 5-day window to evaluate it all. Obviously, if it goes to a direct supervisor first, that department director, that elected official, HR, maybe even your governing authority, they're going to know about it, and you can start being able to adjust and prepare for what's coming if they keep coming up the chain. So I think that first step, being at a lower level, just gives the employer a little more time to react and be ready to respond. But again, it's certainly your process as to however you want to set it up. After you get a complaint and you get into the step, and there may be multiple steps, in fact, there certainly will be multiple steps, then you have to decide, well, what happens at the step? So I've seen some policies where they speak of it as a hearing at every single step. So if I require them to file the written requirement for the grievance, and then I go to step one with the direct supervisor, then we require, say this policy requires a meeting. Well, then that means the employee is going to sit down with the supervisor and they're going to have a face-to-face meeting and talk about it. Now, I would never do that to the exclusion of having something in writing, but I've seen policies require a get-together, so to speak. Then I've seen policies that go only on writing. So they file their complaint, and particularly if it's detailed like I've suggested you would require, then the supervisor gets it. They can make their own determination based upon all that detail. Doesn't mean that they couldn't ask questions, they couldn't ask the employee to provide something else, but it's not done through like a special hearing or meeting process. It's really just based on employee's written package, and then the employer provides a written response back. I tend to favor the written process at those early stages as opposed to requiring a hearing or meeting. The reason I say that is because the hearing or meeting at those lower levels, I think sometimes can produce some negative results for the employer because, if it's in writing, then HR can be aware of it, can kind of control the message, make sure it's appropriate. If there's, any kind of intrigue or drama or emotion with it between a direct supervisor and the employee, sometimes, there's some hotheads and things get said, and then we're, backpedaling from that and having to defend against what happens in the meeting. So I prefer not to have it and just do it all in writing. And then you've got a really clean and clear record. The other thing I think is just logistically important is that if you have a meeting, that does make the timing even more difficult because you have to figure out how to get that scheduled. So I think that's another reason not necessarily to have a meeting in your grievance process at that lower level. If you do have a meeting, then you're really going to have to consider whether you're going to allow evidence or witnesses. I've seen some procedures that would allow, even at the first level, first step, for the employee to come in and present evidence and even to bring witnesses on their behalf. I think that is getting to be too much too soon. I think having the written requirements, which indeed will have some evidence because we've required them to provide all relevant documentation, but I think taking that next step and not necessarily having them testify, if you will, in a personal meeting and then potentially bringing witnesses, I think that's where things can start getting sort of off the rails at that early stage. So I think it's very appropriate to say written package, written response, that's step one, and then if it goes up, it may become more involved. So as you proceed through each step, I think you should have the same requirements each time. So let's say, for instance, that we go to step 1 and it's a direct supervisor. And the employee doesn't like that supervisor's decision. So they're going to go to step 2, and maybe that's the department director in my example. So what should happen is they're going to have a time frame. So the manager, the direct supervisor issued a decision. The employee will have another 5 work days to respond if they wish to advance through the grievance process. And to do that, again, you want to say, when do they have to file it? Who do they have to file it with? And say the same written requirement to proceed. I would say, again, that same slide I showed you where they have to have all of those things in writing. And then I would also include that they need to include in that package their previous grievance and the decision from that direct supervisor. So when the department director gets that package, they've got it from the beginning, they've got the decision of the supervisor, and then they have it all together, and then they can make their decision. So, but again, I think it's important that you just don't get a notice that says I appeal. But again, we have to ask them, specify why, what was wrong with the manager's response, and show me that response. I think that helps to complete a nice package, and it ensures that you're able to respond to really what's going on, and not just looking at that appeal in a vacuum. So what is the last step? As I mentioned, you could start at the direct supervisor, you could start at the city or department director. I would never recommend the first step being the city or county manager, but where does it end? Whatever step process you go through, you have to decide who has the last word. My recommendation is that it be the city or county manager, as opposed to going to the county or city governing authority or to an outside personnel review board or hearing officer or other process. Now, again, if it's civil service, we're going to talk about that in a little bit. Might be a little bit different, again, but that even depends on how you just write your policies. The reason I recommend that the last step in with the city or county manager is because when you get into an appeal to the governing authority or to a personnel review board, it's going to be a public process. It's going to be more involved. It's going to be like a little mini trial. It's going to be expensive. You're likely going to want to have your counsel involved. They're likely going to bring counsel. It becomes much more involved and much more public. Often I see those things become very much a circus. It can also become very political. And so I think if you keep it to the city or county manager level, I think that keeps it in the employee workplace space. It keeps it out of the public. It keeps it out of the politics, hopefully. And it's just a workplace employment decision made going up through the administrative chains. So that's my recommended last step. Now listen, I know there's tons of policies out there where the last step goes either to a hearing officer or to a review board or to even the city council or to the board of commissioners. I'm not saying that's wrong. There's nothing legally wrong with that. I just think that the expense, the politics, the opportunity for it to be such a public circus, that all those things sort of weigh against that being the best process in my mind. But I just recently had a policy update with someone, and I recommended strongly to them that they not have their board of commissioners hear these grievances at the end of the line, and that board of commissioners wanted to be involved in every bloody decision. That kind of gives me concern in and of itself, but that was what they wanted. And so it was driven by the policy and the politics of that government. And so they have a policy that has every single grievance having the opportunity to go all the way through to a presentation at a board of commissioners meeting. And I think that could just be a lot if you have a lot of people taking advantage of that. But it's not illegal. So it's just a matter of your practice and your desire for how you want this process to work. So I kind of mentioned this, but you have to ask the question, is it confidential or is it public? And does it change as you move through the process? So I think plainly, when you're having your manager and your employee meeting, it's confidential. When you're stepping up the chain, maybe to the department director and even to the county manager, certainly I think those can be confidential. Those are not Open Meetings Act issues. But if you get to where that last line of appeal goes to your board of commissioners or to your city council or to a personnel review board, or to a civil service board. Those are going to be public meetings under the Open Meetings Act. They have to be noticed and advertised. Anybody can come and sit and watch them. And that's kind of another reason, as alluded to earlier, it's a very public process if you go all that route for the end of the line. So that's what you need to think about, is how confidential or how public do you want your grievance process to be? And if you answer that question, then you kind of can step backwards then and say, okay, maybe this is where we want to end the process if we want to maintain it as a confidential employee process. Now, I had a question recently, and I don't know if Miss Alicia from Lumpkin's on the line here, but and she didn't write this policy, and I didn't write this policy, but they have a policy that suggests that, actually says that the process is public, even though it's just a meeting with the county manager. So Open Meetings Act would not require that. And Alicia, if I'm stating it wrong, I apologize if you are on this call, but that's my recollection of a question that we had recently with you. And it was a great question because Open Meetings doesn't require it. But even though the law doesn't require it, if your policy puts on yourself a burden that the law does not, well, then that's your new burden. And so when I answer this question, is it confidential or it's public? You know, it is what it is under the law, but if you say something different in your policy manual, then you're going to have to follow that policy manual, even if it's not required under open meetings. So I just want to give that caveat and that warning to be sure that your policy says what you mean in terms of how this would be viewed publicly or not. All right, here's a few just general practice pointers on the grievance process. You want to ensure it's timely filed and it meets these written requirements. So kind of summing up what I've told you before. If it's late, then they're out of time and they're out of luck. And so apply that, but apply it consistently. Apply it every single time, because that's where you can get yourself in trouble, where someone comes in with an excuse like me today. I had to blow out my tire on the interstate. I'm sorry, you know, there's a requirement. You should have filed it the day before your tire blew out. So you have to be consistent, but I would say really, really use those timelines and enforce them. And then enforce the written requirements. Again, if someone submits something in writing and it's just not as detailed, or maybe they leave off an element, I say this to employers a lot, you know, I don't know that we want to get cute and say, oh my gosh, you didn't say what relief you wanted, so we are dismissing you, it's over, you're out, it's final. I would be careful with that, because I'm not sure that's how you want to approach an employee and then make them more aggrieved to go file the lawsuit instead of going through your process, because that's a little more subjective. I think out of time is pretty objective and easy. If it's not the writing that you want, then maybe that's a little more subjective. And what I do though is I would turn it back to them and give them, you know, 24 hours to return it. If they don't return it, then they're out of time and out of luck. You can always seek additional information. So in my recommendation, I say, tell them to provide relevant information, and I would do that, but you may want additional information because that employee may not be giving you something that's key in your mind to figuring out what happened. You don't have to ask the employee for the information necessarily. You can go to the supervisor if it's a department head that's considering it, or the county or city manager that's considering it. You can obtain that information independently, and I don't think you need to feel constrained that you can't do that. I'm not suggesting that the grievance process is a full-on investigation, but I do not want to suggest that you don't have the right to obtain information that you need. And then I always like to say, you know, it's Exhibit A. And it just is. So when you write your response at every single level, remember, wonder and worry about what's at the end of the road. So if you do ultimately get a lawsuit, then that direct supervisor's response is going to be an Exhibit A in that lawsuit. So make sure at every level, I think it's important that HR touch it and be involved to ensure it's appropriate. And even that your counsel be consulted, if indeed it's a very litigious process that you anticipate is going to get ratcheted up to a lawsuit, then you want to be really protective of those documents, because once they're issued, they become exhibits and you will not be able to escape what's on that written page. All right, I'm going to jump now to the formal appeal process. Oh goodness, my battery's running low. I hope we're going to get through this, and if not, I'll plug in just in fact, you know what, I'm going to carry you with me, and I think I'm going to try to plug in. Just don't want to have to take the chance. If you'll bear with me just a second here. You know, with a flat tire today and a flood last week, I just feel like this would be my luck. So I'm going to plug in and I hope that I'm charging. And I don't think I've lost you. Dan, if I've lost you, you need to let me know. Uh-oh. Okay. I think I'm still here.
You're good, Angie.
Am I good? Okay. Sorry about that, guys. I tell you, when it rains, it pours, literally. All right. Let's see. Are you seeing some things on my screen?
We can see your presentation, formal appeal.
Okay, wonderful. Somehow I can't see my presentation
Now
now.
now we're seeing your screensaver.
Hold on just a second, and I'm going to get, let's see if I can get formal appeal. Okay, now, good. Is everybody still seeing me?
Nope, we're seeing you, but the presentation is not, we're not seeing that. I think we're seeing your
Dan, can you hear me
screensaver,
and see me? Uh-oh.
We can see
Dan?
you.
Yeah, good. Okay, I see a thumbs up.
We can see you, but we can't see your screen.
Sorry about that. Now, back to it. So who hears the formal appeal? So formal appeal, here's how I would define this. If you have gone through the grievance process and your final step is going to be, you know, I call the final step a formal appeal. It could be before a variety of different agencies, as I have listed here. But I think once you get to that final step, unless you stop, and I'm going to say that again, unless you stop at the city and county manager, then I think it becomes more formal. And that's what I'm calling this formal appeal. If you don't have your process stopping with your city and county manager, then this may be how you end every single grievance. However, you remember early on when we talked about adverse actions that could be grievable, I said, you know, if you have a termination, you may indeed want to allow for them to skip steps and go right to the end. So if your process ends with a county manager, that's where it ends. If your process ends with formal appeal, then a termination may go straight to this position. So it just depends on what your policy says. But if you end up having an appeal before either a governing authority, which would be your city council or your board of commissioners, and or if you provide for a personnel review board, so there's some jurisdictions that don't have civil service, but they have perhaps a personnel review board, that is fine. And but it likewise would, I think, follow these more formal procedures I'm about to talk about. Or maybe you decide it's just an individual hearing officer. I have one jurisdiction, and I think this works very well for them, is they hire, you know, at the beginning of the year, they have a couple of lawyers on call who act as a hearing officer. They hear the appeal and they make a decision. It's very unpolitical. It takes it out of the administrative workforce in terms of, you know, it's completely neutral, but it doesn't get to that expense and circus and all those things that happen when you have it in front of a public body, like your city council or like a personal review board, or like your other option is civil service board. Now, if you have a civil service system, obviously you're going to hear these things in front of your civil service board, but a hearing officer is something you really might consider as a last step. Now, it can be expensive if you're paying a lawyer to do that, but it could be useful to you. All right, so how do the procedures look a little different here? In some respects, I think they're very much the same in terms of filing. You have to file it within a certain time. You need to provide for that. I think you need to provide a certain time for which you will give notice of the hearing to allow everybody to prepare. So you don't want to say, oh yeah, the hearing's tomorrow. I typically see in a policy that you'll say, you know, that the employee will be provided at least 10 days notice of a hearing to give them time to prepare, time to schedule counsel if they want to. And then often a policy is going to say, and the hearing will be conducted in no more than, you know, whatever it is, 30 days from the date of the request for the hearing, or 60 days, or I looked at one yesterday that was 120 days. So whatever you decide, I think spell out those time parameters, and then you need to try to stick with it. Sometimes you'll have an extension opportunity if both parties agree, but if both parties don't agree, then I think you need to follow your timing strictly. Should it be filed with a different party? So I think typically in your grievance process, it's going either to a supervisor or to HR. Probably you want to still file it with HR. I have some clients who have them file it with the clerk
of the city or county, because if it's before the city council or before the board of commissioners, then that puts their scheduler on notice. I still think the best, no matter who the reviewing board is, I think the best process is probably to have it come to HR. So HR is involved and HR can make sure things go quickly. And then I would follow the same procedures for that written notice of appeal, that they have to follow that slide that says, you know, here's why we're appealing, here's what's been violated, include all the previous level step decisions, and then you get a package for that board or that hearing officer to make their decision. Now, when you're conducting the hearing, it is more formal than the grievance, because the grievance could have all been done on paper. You may never sat across from the employee. Of course, I talked to you about the fact that you could have these little mini hearings or meetings each time at each step if you wish, or you may provide even that you have written documents back and forth until you get maybe to the county manager, and then that's a meeting. It's you know, anything you want, sky's the limit. Whatever you want to do and however you want to do that works within your organization. And sometimes it's resource driven. Who has time to have these meetings, or, you know, how would it best be handled? But it is going to be more formal, but not as formal as a judicial proceedings. You don't need to feel like, oh my gosh, all of a sudden I got to be Perry Mason. It's not LA law. You know, you can still do it without lawyers if you choose, because it is not going to be a judicial proceeding. It will not have formal rules of evidence. So you're not going to have, you shouldn't really have objections, and you're not going to likely have somebody there that's overruling or sustaining those objections. Of course, and I think I'll say this in another slide, you could have a hearing officer as a part of your appeal process, even before one of these boards, who would act as sort of a judge, who could shepherd the parties through. That's very helpful, but it's also expensive. And so you may not want to hire a lawyer that's going to sit there and tell the parties, okay, you're up first, you're up next. No, we're not going to hear that record. We're not going to see that document. Otherwise, I think you have an informal process. Everything kind of comes in. You're not trying to rule out evidence. You just let them submit what they want to submit, and it's informal. You would typically have opening statements and closing statements, and that may sound a little intimidating, but all it means is the employee is going to stand up and say, here's why I'm appealing, here's what I'm upset about. The employer is going to say, here's why the employee's wrong, and then you're going to go through the witnesses and the evidence. Now, here's one practice pointer that I want to note here on this last point. It's really important, again, to the extent that you may end up in litigation, to have the evidence presented that you would want considered on an appeal to a court. Because if a court gets this at the end of the day, then they're going to make their decision based on the record that you've made before this body, this hearing officer, this board. They're not going to take an appeal and then start the process again, or have discovery, or have a whole case. Now, ultimately, it may get combined with some kind of, you know, civil rights litigation, such that you do have a different type of litigation. But if it's simply an appeal of the decision of this board through this process, then it's going to be confined to what evidence was presented before this lower tribunal. So put in your policy, put it into evidence, submit it as evidence to that board or to that hearing officer, submit the ordinance. Those are things, unlike the law, the court, you can say, okay, OCGA section 254, and the court takes judicial notice of that because that's the state law. The court will not take judicial notice of, you know, Smith County Ordinance number 246. They don't know that. They don't know what's, you know, whether it's updated or correct or out of date. So you need to put it in here at this level so that you can have that to make your case at a later appeal. Conducting the hearing, I would recommend recording it. With today's technology, and you may even have, like, you know, video capabilities, either audio tape recording it, video tape recorder. I think that would be a minimum requirement. You could provide that court reporters are optional. Certainly, if an employee is super litigious, they may want to pay for their own court reporter. That's fine. I don't think you want to require yourself to have a court reporter, because once again, that's expensive. But I would at least audio or videotape the proceedings. I think your policy should put some time limits on your hearing. It's not contemplated on a formal appeal that's capping off a grievance process that it's going to go for 5 days. I mean, this is not a trial. So I think very often it would be, you know, one side has an opportunity to present for an hour, the other side can have an hour or maybe more, or just know that it's all going to be completed in one day. But you want to specify what that time parameter looks like so you don't have someone come in that just blows this process out of the water. Another reason that I don't love every process ending in a formal appeal, because sometimes you do get a lawyer, super litigious employee, and they want to go for days and days and days. They want to call every single employee in the department as a witness. And the process is more of an abuse than it is really trying to legitimately get at a correct answer. At the end of the day, it's important for your policies to say this, but the burden of proof should be on your employee. And what that means is if the employee is claiming that we've done something wrong, then they need to prove it. We don't have to defensively prove that we didn't do something wrong. And that's typical in a court of law, that the person bringing the claim has the burden to prove their claim. But go ahead and say it in your policy so that it's not a question. At the formal appeal level, typically both the employee and the employer would have the right to be represented by an attorney. And I think you should say that in your policy so that they are clear that they have an opportunity to do that, not required. You may want to say in your policy that they have to give notice within a certain period of days. I didn't put this on the slide, but I think it's helpful to say within 5 days of the hearing, you have to provide notice of your attorney and a notice of all the witnesses that you intend to have present. That just helps the employer be prepared, and also helps you arrange work schedules. If he's planning to call a bunch of people, or he or she out of the department, then you can arrange for, you know, the work of the county needs to go on even though you've got this grievance process. I would not suggest that you allow non-attorney representation. I've had that question come up before that, you know, Joe can't afford attorney, but Sam's, you know, he's watched a lot of lawyer shows and he thinks he can do it. You know, I'd like Sam, my coworker, to represent me. No, I mean, that's just involving other employees and it gets messy. I don't think that's a good idea. But go ahead and say it in your policies. You know, the employee can be represented by an attorney, cannot be represented by a non-attorney. Easy thing to say, and then there's not a question about it if it's in writing in your policy. Again, here, and I'm going to wrap up quickly. I see that we're already at 3:09. I don't know where the time goes. But quickly here, again, you've got to ask yourself, is this a confidential process or a public process? And with the formal appeal, the answer is yes and no. And you may think, oh my gosh, she's lost her mind. How can it be public and confidential? Well, let me tell you. The Opens Meeting Act is going to apply if it's the governing authority, city council or board of commissioners, if it's a personnel review board, if it's a civil service board. Open Meetings Act is going to apply. That means it is public. Let the sun shine, as they say with the sunshine laws. Anybody can come, the press, all the public, and sit right through that whole process. If you have an individual hearing officer, then I would say it's not public because there's no quorum of anybody that's making a decision. So I think you're okay to have a hearing officer that's not a public process, just like your county manager or city manager can act as the ultimate decision maker without that becoming a public process. But I said yes and no to whether it's confidential or open. So I just told you it was open under open meetings, but how open is open? And so here's where the nuance is. The hearing would have to be open on a formal appeal before one of those boards or bodies during the hearing portion when you're receiving evidence, testimony, and argument. So when the parties are involved, case is being put on, it has to be wide open. But that personnel review board or city council or the civil service board, they can then retreat into executive session to deliberate, to discuss the evidence they've heard, and to make their decision. So they don't have to do that out in front of everyone. So that's why I say it's a yes and a no. The hearing's conducted publicly, but then the deliberation process can be private and executive session among that body. Now, what should come out of that executive session or out of this process is a written decision by this board. Just like at each step of the grievance level, you're going to have a written decision. This one is ever more important because it's obviously going to be what could possibly be the catalyst for an appeal to court. The policies, I think, should provide a timeline for a decision. If you have a board, like a personnel review board or a civil service board, typically those are made up of lay people, and you sometimes just have to put some fencing around what it is they do, because, you know, it's wonderful to depend on lay people for those types of functions, but they're busy people with busy jobs. And if you just say issue a decision, I mean, you may hear from them again in 3 months. So I think it's important that you say a decision will be issued in 5 days or 7 days. What should really happen is they come up with their decision, they put it in writing while they're still together. That's just the functionally best way to do it. But put a timeline in your policy so that that's a requirement really that you're putting on that board, to put some confines on how that decision-making process will go so it doesn't get so strung out. And then that decision is going to be issued in writing. And consider, if you have a board of lay people, whether you have a little template where the board can find, you know, make their findings, make their legal conclusions, and then just sign it. Because as I mentioned, if you want them to try to just accomplish it all in that day while they're there, they're not going to have, you know, someone to type up some lengthy epistle on what all their opinions are, nor do they probably have the confidence to want to do that. It may be a very simple thing that says, we affirm the decision of the employer, you know, we disagree or deny the allegations of the employee, and whatever, you know, their finding is as a result of that. And it's just to fill in the blanks. I don't have a template like that, but I've seen people use those before. I think it's simple to create, and I think that would be recommended if you're depending on one of those boards. Now, if you have a hearing officer attorney, or you have a hearing officer attorney who's participating with the board, probably less important, because that hearing officer attorney could write the decision without too much concern. All right, so I'm just going to back up and say again, why do I not recommend casually adopting appeal procedures that end up before these boards? And again, I've kind of said it, but I just want to bring you back to it as if you're debating about how you want your steps to go. I think it's a circus. I think it costs a ton of money. And then the guy on the end just looks tired and worn out. And that's because it really is an exhaustion of resources. It's going to be putting on really a full trial. And so it may be more than you want to bargain for, particularly as the end of every single grievance for a suspension or a demotion. As a termination, I think, yes, I think it's appropriate, but maybe not every single grievance. That's where I want you to really think about whether that is the process you want for the end and final step for every grievance. One last point I want to make to you as you go through this process, you could decide that there's going to be a settlement. You know, you've heard what the employee's complaining about. Once you hear that, you may realize, okay, well, maybe there's a little something to it. Maybe that manager didn't handle that correctly. So maybe there's a resolution that comes of it. Maybe a disciplinary action is withdrawn. Maybe a suspension that was for 5 days is reduced down to 1 day, or maybe a demotion is rescinded and they're put back into their position. If that kind of result comes out of this grievance process, then that means it did its job. I mean, this is supposed to be an interactive, informal process that solves a problem. I think typically we think about it as a litigious process where somebody wins and loses, but it could be that you have an opportunity for the first time to hear something that's not going on properly, and you can address it and you can fix it before it gets worse, before it impacts other employees. So maybe a resolution comes out of this, and not just a winner and a loser, and everybody wins. If that happens, though, probably the records are still all going to be public record and in that employee's personnel file. So if I've issued a 5-day suspension and then I decide, okay, I will rescind that, you don't have to serve it, I'm going to apply a 1-day suspension, under the Open Records Act, that doesn't mean you get to just pull that document out and destroy it. There's no opportunity to do that under the law. So those records would still be there, but there would be a process document that shows what happened, that through the grievance process, that 5-day suspension is reduced to a 1-day suspension, or whatever it may be. But just wanted to be mindful that it doesn't mean you start purging records, or, you know, if in the grievance process they don't like it, and you believe that the employee's right, the manager was wrong, doesn't really mean that those documents go away. It just means that you would document that. Manager was wrong, employee was right, and it's put in the form of the decision on the grievance. Now, if the settlement does result in separation, as opposed to termination, that it's agreed upon that, okay, the employee's going to leave, or maybe, as I told you, this one employee example, we weren't even proposing to terminate her. She was kind of trouble and complaining about everything, but when we said, what do you want? She wanted to go. So it ended up in a separation. And if you go that route, then consider a separation agreement that gets release of the county or the city. And under that circumstance, pursuant to the statute that I cite here, you can purge the records. but only under those circumstances. And I am going to be sending out a separation agreement format for y'all. Someone asked me for it last week. I've gathered all those records, and Dan's back in town. I'm going to get them to Dan this week, and he'll be getting this out to you. So that could be the end of this grievance process. And that, under that circumstance, you would potentially be able to redact documents. And wrapping up here, civil service system. I'm just going to make a couple quick comments since we're going long today. If you have a civil service system, a couple things I want you to think about. Once a position is covered, it's in civil service. You can't just take it out. And you can't just take it out because the employee changes. Under the law, it's the position, not the person. Just keep saying that over and over. It's the position, not the person, that's covered. Unless you go through a local legislation process to either, remove the civil service system altogether, which I went through just recently in one county down in South Georgia. It's kind of a cumbersome process, but you can do it. Or if you go through local legislation to remove just certain positions, like a command staff, if you will. I've seen jurisdictions go through that kind of a process. But just be mindful that you can't willy-nilly move people in and out. It's got to be a position-based situation. If you don't have a civil service system and you want one, then there's a proper process through state law where you have to go through different steps. If you want to cover elected officials, then they have to opt in. I'm not really going to go through that in detail because I don't know that anyone who doesn't have a civil service system necessarily wants one. In HR, I don't think that's your goal. It may be, someone running for office, maybe touting it as an initiative, but I didn't think it'd be a good use of your time to go through how to adopt a civil service system unless you're interested in it. If you are, let me know. I'd be happy to talk you through it, show you the statutes. Why you might want one is the whole fundamental process of civil service is a protection of your job force. So, when elected officials come in, that they don't come in and fire everybody, that there's some job protection. But under your handbook policies and based upon, discrimination laws and all the protective employment laws that we have today, I think civil service is maybe less relevant than sometimes that it was in the past. But still, a lot of jurisdictions, really swear by it. And it is a positive thing, I think, for employees. It may not be viewed as positively for the elected officials. The policies and procedures are largely going to be the same. If you have a civil service system, then everything that I talked to you about in terms of the grievance and the formal appeal, it's all going to go that same way, except it's going to be before the Civil Service Board as you end the process. Even under civil service, though, you would have that informal process going up the steps until you get to a final hearing before a civil service board. So concluding quickly, moral of the story is have good rules, follow the rules, document, and document like it's Exhibit A, because the end of the road could very well be litigation. And that's all I have, Dan. I'm sorry I ran a little bit long, everyone. Sorry for my technical difficulties with my computer, but I'd love to take any questions that you may have. And I hope I can hear you, Dan. Can I hear you?
Can you hear me?
I can't hear you. So let me figure out why I can't hear you. I'm not sure why I can't hear you. Yeah, Dan, Angela? I'm not hearing you for some reason. Oh, I tell you what, let me do this. I'm going to unplug.
Can anybody else hear me?
I may cut you off, but I'm going to try to unplug. Let me see if I can hear you now.
So I think everybody else, can you hear me, Angela? Yeah, I think people can hear me. So I'm going to say.
I apologize for having these technical difficulties today, but I cannot hear you.
I'm going to say I'm going to call Angela. We're going to stop. If you have questions you want to ask her, please.
I'm so sorry I cannot hear. And if people have questions, I would love to answer them. So perhaps maybe you can just send them to me in the chat and I can kick some answers back in an email. If you want to hold on, I'll see if someone can help me. In fact, I'll try that real quick. You can help me see why I can't hear. I ended up. Okay, I've got a quick technical assistant to see if I can make this work. I had to plug my computer in and I unplugged it because I was having my battery go dead. Click that.
drop down again.
Want to do it?
You have anything?
Okay. Give me just 2 seconds. We'll see if we can solve this. If not, I'll take your questions through email. I think going back and forth with plugging in and out my battery is what doomed me here. It was not working when it's plugged in there. That's so strange. Can you move it over there so we can at least see him? Dan, see, can I hear you now?
Can you hear me, Angela?
Yes, I'm so sorry. Thank you, Grace. Okay, I'm not going to touch anything, and I think my battery will last. I apologize, everyone.
Angela, first of all, great job. Thank you so much. We are running very short, and I actually need to move on to another meeting, so I apologize for that. What I'd ask you to do, if people have questions they would like for Angela, just send me an email at dbeck@LGRMS, and I will forward those to Angela. When I send out the recording link and others, I'll have those answered, if that's okay, Angela.
That's perfect, and I apologize for the extra time I took and for my technical difficulties today, but
not a problem. Always fantastic. Always fantastic. Everybody, a round of applause for Angela.
thank you. Thank you. Thank you.
Thank you so much. Great job. And we will talk later.
Okay, thanks, everyone. I'll look for those questions. Again, I apologize. Have a great
No
day.
problem.